Exam Scholar, Real Estate Edition.
Question 1. Which of the following is not a way in which mortgages and trust deeds differ? A. Securities. B. Title. C. Statute of limitations. D. Parties. Answer. A. They are both security interests in property. They provide the legal right to have the property sold in the event that the borrower defaults. Question 2. The statutory dedication process is completed when A. The appointed representative of the city or county signs accepting the dedication. B. The final subdivision map is recorded. C. The dedicated area is completed. D. Local authorities deliver a signed acceptance to the subdivider. Answer. B. Upon the final subdivision may being recorded. If the subdivider has dedicated an area through a dedication certificate and the dedication has been accepted by the properly authorized official, then the recording of the approved map would be the final step in the statutory dedication process. Question 3. When duly recorded in the county where the property of the judgment debtor is located, an abstract of judgment for money awarded by a court becomes A. An involuntary lien. B. A voluntary lien. C. An attachment lien. D. An equitable lien. Answer. A. A lien is a money encumbrance. In this instance, the encumbrance is placed on the property without the owner's consent and is, therefore, involuntary. Question 4. At 12 o'clock noon, Baker made an offer to purchase a single-family residence. He instructed his real estate broker not to present his offer until 6 p.m. By 6 p.m., 3 more offers had been submitted. The real estate broker should A. Ignore the other offers. B. Present all offers to the property owner in the order they were submitted. C. Present all offers to the property owner simultaneously as soon as possible. D. Wait until the seller acts on the first offer before presenting the other offers. Answer. C. The rule of agency is that all offers must be presented to the seller and let the seller make the decision as to which offer to accept. Question 5. One side of a section equals how many feet? A. 43,560. B. 5,280. C. 2,640. D. 1,000. Answer. B. A section is 1 mile on each side. 1 mile equals 5,280 feet. Question 6. Which of the following is required in a valid homestead? A. Statement that claimant is residing on the premises and desires to claim it as a homestead. B. Statement giving the exact cost of the homestead at time of purchase. C. A description of the property including a description of the improvements. D. Signature of both husband and wife. Answer. A. Any person filing a homestead is required to reside on the premises at the time that he records the homestead and to sign a statement that he desires to claim it as a homestead. The person claiming a homestead does not have to give the cost, or a description of the improvements on the property, and it can be filed by either a husband or a wife. Question 7. The broker, as agent of the seller, owes the buyer A. Only a duty to disclose any item which relates directly to the sales price of the property. B. The same fiduciary obligations he owes to the seller. C. Only the duty to answer questions honestly. D. The duty of honestly and fair dealing. Answer. D. This deals with the responsibility an agent owes the buyer when the licensee is the agent of the seller. He owes the seller fiduciary obligations, the buyer, the duty of honestly and fair dealing. Question 8. Harry owns a building in a commercial area of town. Tina rents space in the building and operates a bookstore. In Tina's bookstore, she has installed large reading tables fastened to the walls and bookshelves that create aisles from the front of the store to the back. These shelves are bolted to both the ceiling and the floor. Which of the following best characterizes the contents of Tina's bookstore? A. The shelves and tables are trade fixtures and will convey when Harry sells the building. B. The shelves and tables are trade fixtures and may properly be removed by Tina before her lease expires. C. Beck. As Tina is a tenant, the shelves and tables are fixtures and may not be removed except with Harry's permission. D. Because the shelves and tables are attached to the building, they are treated the same as other fixtures. Answer B. Common law protects business tenants who install fixtures for their business by treating these trade fixtures as their personal property and giving tenants the right to remove them before the end of their lease. Any damage to the building due to removal is to be repaired by the departing tenant. A licensee who participates in the sale of business property should make known to purchasers what, if any, trade fixtures there are that will not convey with the building. Question 9. A real estate license is A. Constitutionally protected right of the individual. B. Privilege granted by the state. C. Right granted by the Office of the Attorney General. D. None of the above. Answer B. Like a driver's license, it is a privilege. Question 10. If, in a transaction, the amount made as a deposit is not sufficient to cover the monetary damages incurred by a party to the real estate sales transaction, the following party could not file an action in a court of law. A. The buyer. B. The seller. C. A real estate broker acting as an agent for his principal. D. An attorney action for his principal. Answer C. A real estate broker acting as an agent for his principal is a special agent. The broker's powers are limited to acting in the sale of the property. He has no power to file a court action for his principal. Question 1. Which of the following items is usually considered to be a cost of home ownership? A. Land depreciation. B. Improvement appreciation. C. Amenity value. D. Interest lost on the owner's equity. Answer D. The interest that is lost on owner's equity is usually identified as lock-in equity. This term applies to the fact that the owner cannot utilize the funds for other investment purposes. Question 2. Abel submitted an offer to purchase Blackacre. During the escrow period, a local credit reporting agency submitted detrimental information which Abel contested. Abel made repeated attempts to get the matter corrected and he was denied access to the information reported to the agency. Abel may A. Bring an action to recover punitive damages of no more than $5,000. B. Bring an action in a court of appropriate jurisdiction to recover actual damages. C. After a prescribed time, require the reporting agency to delete such information from the report. D. All of the above. Answer D. All choices are open to the principal in question. Question 3. Mr. O'Reilly paid an owner $10 for an option containing this clause, option to be for 60 days from June 1, 1967. Upon exercise of option, holder is to purchase within 30 days thereafter for all cash consideration. On July 10, Mr. O'Reilly sold and assigned his option for $1,000. On July 28, the new holder notified the owner that he would purchase on August 15. The owner claimed the option was void. The option was A. Void, because the holder sold it. B. Void, because date of purchase was not within the option period. C. Valid, even though Mr. O'Reilly sold it, but August 15 was too late for date of sale. D. Valid, and assignee could purchase on August 15. Answer D. Inasmuch as the terms of the option are for all cash consideration and no unsecured promissory note is involved, it must be sold or assigned, because the new holder exercised the option within the 60 days period, before July 30th, and purchased the property with 30 days of the exercise date, before August 30th, the option is valid. Question 4. Other than non-dischargeable debts of a bankrupt debtor are cut off, discharged. A. Publication of the notice of the petition in bankruptcy. B. Discharge in bankruptcy. C. The first meeting of creditors. D. Filing the petition in bankruptcy. Answer. B. Debts are cut off, discharged, the date bankruptcy court issues a discharge. Question 5. In which of the following ways may an agency relationship not be created? A. Verbal authority. B. Necessity or emergency. C. Post hoc ratification. D. Subordination. Answer. D. Subordination means lie, trickery or deceit, hence, it cannot be a valid way to create an agency. Question 6. A person and his property that is encumbered by a first deed of trust are in Chapter 7 bankruptcy. The court can sell the property and use the proceeds therefrom to pay debts owed to unsecured creditors. B. Holder of the first deed can foreclose. C. Debtor need not make payment on the promissory note secured by the first deed of trust. D. Debtor can sell the property. Answer. A Chapter 7 bankruptcy petition creates an automatic stay of a creditor's foreclosure against the debtor. Creditor must file a petition with the bankruptcy court seeking relief from the automatic stay and approval to institute foreclosure action. If the note is oversecured by collateral, the bankruptcy court trustee may sell the property, pay the secured creditor, and use the excess proceeds to pay unsecured creditors. If the debtor does not make payments on the note during the automatic stay, the bankruptcy trustee will pay interest to the secured creditor from the date of petition to the date of sale. Question 7. A loan that is secured on easy terms and with a low down payment usually results in A. Increased financing costs. B. Decreased financing costs. C. No difference in financing costs. D. Faster amortization. Answer. A. The lender is not going to be given easy terms or long-term financing without securing something in return. This usually results in increased financing costs. Question 8. Insofar as a residential neighborhood is concerned, which of the following would offer the least protection against blighting influences on future development? A. Natural or artificial barriers. B. Partially built-up neighborhood. C. New neighborhood in the path of directional city growth. D. All families with similar income. Answer. B. A partially built-up neighborhood would have a definite tendency for blighting, because it was not completed and there would be a potential for vandalism. Question 9. In negotiating certain loans, a broker is required to fill in all of the items on a broker's loan statement form. The following item must be inserted. A. What the borrower intends to do with the proceeds of the loan, less expenses. B. A statement of the value of the property supported by a proper appraisal. C. The date on which the borrower acquired the property. D. The amount that will be charged by a qualified agency to render a report on the financial capacity of the borrower. Answer. D. The loan broker law requires, among other things, that the broker's loan statement contain estimated costs including appraisal, escrow, title, notary, recording and credit investigation. Question 10. Which of the following is not a characteristic of an easement? A. It is an interest which can be protected against interference by third persons.
B. S pause. Second equals 0.80 pause. It is capable of being created by a conveyance.
C. It is considered a non-possessory interest. D. It is an interest that can be terminated at will by the possessor of the land. Answer. D. The possessor of the land is the owner of the land. He cannot terminate the easement at will. Question 1. When a loan is fully amortized by equal monthly payments of principal and interest, the amount applied to the principal A. increases while the interest payment decreases by a constant amount. B. increases by a constant amount. C. stays the same. D. decreases while the interest payment increases. Answer. A. When amortizing a loan by equal monthly payments, the amount applied to the principal gradually increases while the amount applied to interest gradually decreases. Question 2. In order to bring court action to collect a commission earned for negotiating a month-to-month rental, the broker A. must have a written listing signed by the owner of the property. B. could not have charged more than 25% of the first month's rent for his services. C. must have been registered with the real estate commissioner as a rental broker. D. he'd prove only an oral agreement to pay a commission. Answer. D. Contracts which are to be performed in less than 1 year, such as a month-to-month rental, and agreement leading up to the final contract, listing for a month. Question 3. A primary source of funds for residential mortgage financing is A. Federal Home Loan Bank. B. Federal Savings and Loan Insurance Corporation. C. Federal Savings and Loan Associations. D. Federal Housing Administration. Answer. C. The primary source of funds for residential mortgages is federal savings and loan associations. The money ultimately comes from household savings, but the sources for the loans are the savings and loan associations. Question 4. A balloon payment is a part of A. Fully amortized loan. B. Final payment made on any loan secured by a trust deed. C. Partially amortized loan. D. None of the above. Answer. C. A balloon payment is defined as the final payment when it is an amount more than twice the smallest payment and the loan is classified as partially amortized as opposed or fully amortized. Question 5. What actions can the Federal Reserve Board take to increase the supply of money and credit in the national economy? A. Lower the cash reserves required by banks which are members of the Federal Reserve Bank system. B. Sell U.S. government securities in the open market. C. Raise the discount rate charged banks which are members of the Federal Reserve Bank system. D. Increase the requirements of banks which are members of the Federal Reserve Bank system. Answer. A. If the Federal Reserve Board lowers the reserves required of member banks, it will increase the amount of money available in the economy. Question 6. When reading an amortization table/chart, the amount shown as the payment based on a given loan amount, rate of interest and term indicates A. Yield. B. Both principal and interest. C. Interest. D. Principal. Answer. B. An amortization chart, table, will show the monthly payment which includes both principal and interest required to pay off a loan of a given amount, rate of interest and term. Question 7. The security of a loan made on real property depends upon A. The borrower's credit. B. The value of the property being liened. C. The stability and value of money. D. All of the above. Answer. B. The property is the underlying security for the loan. Question 8. The requisites of a grant deed when compared to a land contract of sale may differ with respect to A. Interest conveyed. B. Signatures of the principal parties. C. Designation of purchased price. D. All of the above. Answer. D. A grant deed and a contract of sale differ in the signatures of the principals, as a grant deed requires only the signature of the grantor, but the contract of sale requires the signatures of the vendor and vendee. They generally do not disclose the purchase price in a grant deed but must in the contract of sale because it is a contract. A grant deed has implied warranties and the contract of sale has no implied warranties. Question 9. In advertising a listed property for sale, a broker may not legally A. Run an ad which does not give the listing price of the property. B. State the kind of financing available. C. Fail to state the street address of the property. D. Run an ad giving the impression that he is the owner of the property. Answer. D. For a broker licensee to use an ad which gives the impression that the property is being sold by the owner himself/herself when the broker has, in fact, secured a listing on the property, would constitute substantial misrepresentation. This kind of action is unlawful. Question 10. When an owner of real estate sells the property to someone else, which of the sticks in the bundle of legal rights is he or she using? A. Exclusion. B. Legal enjoyment. C. Control. D. Disposition. Answer. D. To dispose of something is disposition. The legal term often applied to this stick in the bundle of rights is alienation. It is a right often taken for granted but did not exist in feudal times or in countries in which the land belonged to the people, the government. Question 1. Commissions of a licensed real estate broker specializing in property management are A. Based on the first year's rent. B. Based on a percentage of the gross rents collected. C. Based on a percentage of the rents expected to be collected over the life of the leases. D. Equal to the first and last month's rent. Answer. B. Commissions are usually based on a percentage of the gross rents collected, not those expected over the life of the leases. Question 2. An interest in real property can be acquired through adverse possession or by prescription. The interest acquired by prescription is A. The right to use the land of another. B. An equitable title. C. A legal title. D. A private grant. Answer. A. A prescription refers to an easement, which is the right to use the property of another. Question 3. In imposing restrictions on a new large subdivision, the most practical method is to A. Record the restrictions in the manner provided by law and make reference to them in each deed. B. Publish the restrictions in a newspaper of general circulation. C. Post the restrictions on the property. D. Post the restrictions as covenants in all the deeds. Answer. A. It is impractical to place the restrictions in each deed since there are usually a great number of restrictions. It is better to record the restrictions and make reference to them in each deed. Question 4. A broker receives an offer on a property and a prospective purchaser gives him a $1,000 deposit. He places the deposit in his trust account. After all the conditions of the deposit receipt have been fulfilled, the buyer decides that he wants to back out. A. Give the $1,000 to the seller. B. Give the $1,000 to the buyer. C. Keep the $1,000 in his trust account. D. None of the above. Answer. The deposit belongs to the seller, once the conditions of the deposit receipt have been fulfilled. Question 5. When a developer sets up a subdivision, he places certain restrictions on each of the lots. Of these, experience has shown which of the following is least likely to be enforced. A. Limitations on size of each lot. B. Limitations on the dollars allowed for improvements on each lot. C. Limitations on square footage of each home. D. Limitations on the number of stories or total height of structures. Answer. B. Limitations for the amount of dollars allowed for the improvements on each lot is the most difficult type of restriction to enforce, because the value of the dollar changes and thus, the quality of the improvements would change. Question 6. The Hutchinsons, prospective buyers of a home, request a broker to find a loan for them. He would mostly likely contact A. An institution lender, such as bank or savings and loan association. B. A Federal Reserve Bank. C. The Federal Housing Administration. D. An FHA appraiser. Answer. An institutional lender is more likely to be advancing the funds towards the purchase of a home. The Federal Housing Administration and the Federal Reserve Bank are not lenders in the home loan market. Question 7. Mortgages and trust deeds differ in all of the following ways, except A. Parties. B. Securities. C. Statute of limitations. D. Title. Answer. B. A mortgage and a trust deed are security interests in property. They provide the legal title to have the property sold in the event that the borrower defaults. Question 8. After 6 lots have been sold in subdivision, the real estate commissioner was informed of misrepresentation in the sales program. The commissioner could halt the sale of more lots by A. Voiding the public report. B. Attaching the unsold lots. C. Issuing a desist and refrain order. D. Filing an accusation in court. Answer. C. The best course of action available to the commissioner would be a desist and refrain order. Such an action would immediately halt all future sales for marketing of the property. Question 9. A subordination clause in a trust deed benefits A. The beneficiary. B. The trustor. C. The trustee. D. None of the above. Answer. B. A subordination clause allows the trustor to obtain a later trust deed which will move into prior position, as regards to payment, in case of default. It is to the trustor's advantage, not to the beneficiaries. Question 10. An agency relationship can be established by all of the following, except A. Agent volunteering. B. Oral agreement. C. Implied statement of law. D. Agreement of principle. Answer. A. An agent cannot volunteer to be your agent. An agency can be established by an agreement with the principal. It can be implied, by your acts, the principal accepts your agency. It can be an oral agreement. Agency does not have to be in writing, but the commission agreement must be in writing. Question 1. In portfolio risk management, a lender considers A. Diversification. B. Liquidity. C. Reserves. D. All of the above. Answer. D. In portfolio risk management, A lender determines what type of loans to have in his portfolio. Factors are: how quickly can I sell these loans? What are my reserves? How diversified are these loans? Are they all business? Are they all residential? Are they a mixture of business and residential? Question 2. You sell a note with a face value of $12,000 for $10,000. You are A. Discounting the note. B. Amortizing the note. C. Committing an act requiring a real estate license. D. Committing fraud. Answer: A. Any time you sign a note or sell a note and the amount you receive is less than the account stated on the face of the note, you are discounting the note. Question 3. An able buyer means one is A. Financially able. B. Having the ability to obtain the necessary funds to purchase real property. C. Having the ability to obtain necessary financing. D. Any of the above. Answer: D. Any of these would indicate an able buyer. Question 4. The right to foreclose a trust deed, under a trustee's power of sale, outlaws A. In 4 years. B. In 3 years. C. In 2 years. D. Never. Answer: D. A trust deed is not a contract, but rather a conveyance of the naked legal title with the power of sale from the trustor to the trustee. Therefore, the trustee retains the right to sell the property under the trust deed at any time for the benefit of the beneficiary. The conveyance has been performed and thus is not under the statute of limitations, therefore, it never outlaws. Question 5. Broker Styles took a listing from a seller using the standard listing form. 1 week before the listing expired, the broker informed the seller that he had a prospective buyer named Bennett. After the listing expired, the seller listed with broker Johnson. Johnson showed the property to Mr. Bennett and obtained an offer that was accepted. Under these circumstances, A. Broker Styles gets a 6% commission. B. Broker Johnson gets a 6% commission. C. Both brokers get a 6% commission. D. Broker Styles gets a 3% commission and Broker Johnson gets a 3% commission. Answer: B. In the safety clause of the standard listing form, Broker Styles would agree to relinquish his safety period if the property were listed with another broker. Question 6. A loan created with more than one borrower is usually added to the promissory note for the protection of the lender. A. Beneficially. B. Jointly and severally. C. Universally. D. Unconditionally. Answer: B. When there is more than one borrower on the note, the promise and obligation to pay that balance is the responsibility jointly of all the co-borrowers, and also each individual is severally liable for the full debt. Severally, in law, means individually. Question 7. Mr. and Mrs. Johnson, who had been shopping for a new home, found one that they liked very much, but because they felt the property was overpriced, they decided not to buy it. Their reason for not buying was probably based upon the principle of A. Conformity. B. Substitution. C. Highest and best of use. D. Anticipation. Answer: B. It must be assumed that our buyer has found another home that was equally desirable but at a much lower price. This is the idea behind the principle of substitution. Question 8. When a broker misrepresents his principal's property to a buyer, he could cause his principal to be subject to A. A court action for damages by the buyer. B. A rescission of the sale by the buyer. C. Civil responsibility for compensating the buyer for misrepresentation of the broker. D. Any of the above. Answer. D. The principal is responsible for his agent's actions. If misrepresentation occurs, there should be a rescission of the sale or civil court action for damages. Question 9. An owner of a 5-unit apartment building that is located within the city limits intends to convert the building into 5 condominium units and offer them for sale to the public. Under these circumstances, the developer A. must obtain a public report from the Real Estate Commissioner under the Subdivided Lands Act. B. must file a map with the city under the provisions of the Subdivided Map Act. C. is exempt from the Subdivided Lands Act and the Subdivision Map Act. D. must comply with the Subdivided Lands Act and the Subdivision Map Act. Answer. B. Any type of subdivision located within the city limits is exempt under the Subdivided Lands Act, but a condominium conversion of 5 units or more is covered under the Map Act and must be filed with the local authorities. Question 10. After acquired title is conveyed in any trust deed for the benefit of the beneficiary, it conveys A. personal property later affixed to the real property so as to become real property. B. improvement built on the land after title is acquired. C. additional land acquired afterward by the trustor. D. all of the above. Answer. D. After acquired title refers to title to fixtures or other real property items that become part of the land that is securing the existing trust deed. If a lot serving as security for a loan made 10 years ago has land affixed to it, that land becomes encumbered with the lien made 10 years ago. If additional improvements, such as a swimming pool, added bedroom or new landscaping are added to the real property, they to become encumbered with a trust deed lien made 10 years ago.
Exam Scholar, Real Estate Edition.